It is my opinion that we are perishing of, that's supposed to say for our lack of knowledge, or basically for ignorance. Although I wish the pirates would release the slaves from the house of bondage, it is not their nature, as they require a vessel to feed upon and live through. It is our duty to free our own minds. If a claim is brought against the estate, the will is the law. If your will is appropriately filed, the court is required to notify the executor of the estate that a claim has been made against the estate, thereby affording the executor sufficient time to resolve the matter in accordance with the intentions of the estate. The testator who wrote the, excuse me, let me skip that part. Um, what is most important in the will is the rules of administration. The administration section should establish or adopt a procedure for adjudication and making claims against the estate. I encourage you to include your nation's court system or annex and attach the rules and guidelines governing the administrative process of which the executor will appropriately recognize and respond to. This is addressed in the same manner such as a court posts its local rules. One may also consider accepting for value and annexing to the will any Bill of Rights or human rights instruments such as UN Resolution 61-178, Declaration on the Rights of Indigenous People. Doing this puts in place a charging instrument, allowing the measure to be set whereby any trustee denying you due process may be held liable and charged. Um, and charged. Basically, you can charge them based off of that instrument. Now, so now we just kind of went over the will, which I believe is the first important document for establishing your status. And although I read over this, I just want to kind of reiterate some things and point out some things that you can understand. Now, many of us are familiar with straw men and things of the such. Now, the straw man is really a trust, but when that trust is being subject to some type of proceeding, whether criminal or civil, you need to look at the, this is kind of a hard concept for me to explain, but although these straw man accounts are trusts, when they become subjects of a court system or a proceeding, they're now in a state. And technically, an estate, a state is kind of, how can I say it? It's a state of being, if you will. So you can look at it like the estate of your trust. Like what is the status of your trust? This is kind of a better way to look at it. But the point that I wanted to make is that whenever you're facing a criminal or civil proceeding, what is occurring is that someone is trying to adjudicate a claim against your estate. Somebody is claiming that they have been damaged, and they're bringing the claim against your estate expecting to be compensated. So the reason why you want to have a will, well, let's think about it like this. Most people don't have a will on file. And now when you hear the term will, don't only think of it as the document, think of it about, what is a will? A will is your intentions, what you're putting forth, what your desires is, right? The same way a corporation has a corporate charter, or the same way a state has a constitution, is the same way that your Sestake trust should have a will or an intention on file, because at some level it's being construed to be a corporation. And if you have no declaratory document establishing the intent or the rules and the regulations, then that's what allows the judge or another public trustee to assume the role as the administrator or the executor for your estate, because they say, hey, I'm a public trustee and I can assume this duty because the office is currently vacant and not occupied. You can just Google around, not even in the sovereignty or secure party movement. One of the most important things that you're going to find in every will is the will establishes the executor. And the will also establish an executor is pretty much the chief administrator over the affairs of the estate. And he can appoint fiduciaries and trustees, and he can instruct them what to do. And this is not something that has just got, this is not something that was just made up in a secured party or the creditor movement. This is well established in law and in the legal system. So it would very much benefit you to provide a will solely for the purpose of establishing who the executor is, because this will allow you to have a stronger standing in court, because now they have to recognize that. If you have a will on file and it's a matter of public record, and there's somebody trying to adjudicate a claim against you, say let's say in like a criminal matter, well, now you can pull that file and you can file that into the case, and it will become a matter of the record of who the executor of the estate is. Now you're putting the public trustee in a awkward position. And when I say public trustee, I'm talking about a judge or a magistrate or whoever it is sitting in that role, because they are 100% very much aware. Now I'm talking from experience here. I'm talking from assisting people that have used this type of remedy. You put them in a very uncomfortable position, and you can actually see frustration about them because they lose their power and they lose their authority once they know that in writing and certified by affidavit and recognized and acknowledged by their court that there is an executor for the estate. Now, something else I wanted, I touched on it also in this article, is the administration section of the estate. That discusses what the intention is, or what the will is, for how administration and adjudication should take place against the estate. That's the I can't say that word. Testator's will. Now, a will is not just a mere affidavit. From my studies, the will is probably the highest form of a declaration that there is. And you have to look at it as such, because, again, if you're denying someone to have an intention or will, then you may as well come out and say, hey, you're just a slave, which is against all kind of law. Enforced contracts, being forced to comply with a contract that's one-sided, or that you do not agree to, or that you do not consent to, is basically the definition of slavery, right? So denying somebody the opportunity to manifest their will is serious. Now, as a result of that, I personally believe that is a lot of reason why people always say, go to an attorney to file your will. And it's been my experience that a lot of attorneys take your sovereign control of your estate out of your will by the verbiage and the words that they use. So I think you would be better served to do your research and file your own will. And then not only that, a lot of attorneys will not put your will into the record. They will hold it at their office, or they will hold it in a safe somewhere and wait until your physical body is off of this earth before they file your intentions. So to me, it seems like it's a counterproductive system that's set up in a way to keep you in ignorance and to give you no control over your vessel, and to wait until you pass this world and then to reveal what should have been given to you while you were here. It's really something to think about. But anyways, I guess because this video has went on long enough, I would just make this the first part, and I'm going to discuss all three of these documents that I think you need to establish your status. And I'm also going to discuss the fourth step, which is not necessarily a document, but something that you may also want to consider. And you just got to bear with me. You may not understand how all these things work, but if you go to the site and you read, and again, that's under the foundation and the establishing your status step by step, you can read and you can click and download these documents. They're templates, so make sure you make them personal. And when you get through all of these, you'll see how they work together. So in the next video, I'm going to talk about the next document, which is your letter of executorship, which should occur after you file the will, and it should correspond with what's written in the will. Thank you for watching, and make sure you visit www.thctrust.org and continue to visit.